everybody is before we go on the record. I think I used that up last time. Obviously, I know who we are, I can barely see you over there, I know.
Jack Jordan is corporate counsel for Ottawa County.
Okay, all right.
And Steve Coleman.
Okay.
Good morning, Your Honor. Mike Homier on behalf of Commissioner Jacob Bonner.
What's your last name?
Homier, it's H-O-M-I-E-R.
H-O-M-I-E-R. And of course, there's an instruction right on the very start.
Yeah.
I'm sorry.
Good morning, Your Honor. Michael Bogren on behalf of County Clerk Justin Roebuck.
Oh, right, okay. That's what okay. All right, then let's go ahead and go on the record. Okay, we are on the record in file number 23-7180CZ in the matter of Adeline Hambley versus Ottawa County et al. I'm Judge McNeil present. I'm gonna have, I just made them tell me who they are, and I'm gonna have you all introduce yourselves again for the record. I'll start with you, Ms. Howard.
Good morning, Your Honor. Sarah Howard here on behalf of the plaintiff, Adeline Hambley.
Morning, Your Honor. Dave Coleman appearing on behalf of defendants. Also here co-counsel Stephen Coleman and Jack Jordan. And we have Commissioners Moss, Seilster, Bergman, and are also here.
Are also present, okay.
Good morning, Your Honor. Michael Bogren. I have a special appearance on behalf of County Clerk Justin Roebuck, and Mr. Roebuck is also present.
Okay, thank you.
Good morning, Your Honor. Mike Homier. I also entered a limited appearance on behalf of Commissioner Jacob Bonema. Mr. Bonema had some garage door problems this morning, but he assured me he would be here promptly at 9, so I expect him anytime.
Okay, I know we actually, I think, started maybe 1 minute early, sorry. All right, then we have a number of motions that have been filed. I'm gonna address some of them first. I think we did not do, I don't think I addressed on the record last time. Ms. Howard had filed a motion requesting leave to file a reply brief. That motion is granted. I do have that brief, but we don't need to have an argument on that. Then we have a number of motions that Mr. Coleman has filed more recently. Because this was originally set for an evidentiary hearing on the motion to enforce the settlement agreement. I have received, and I wanna make sure we go over on the record because sometimes, I don't have access to the Ottawa County database, so sometimes, like for example, I didn't know you had filed a limited appearance, that didn't get to me yet, so I wanna make sure we have it all clear. I have defendant's motion for a protective order that we need to deal with on defendant's motion to cancel or adjourn the evidentiary hearing. I'm gonna deal with them both together. I have read what everyone has filed. I do wanna state for the record, I already made a decision that we would have an evidentiary hearing. I do not believe I needed to do a written order that said that. But I'm gonna give you probably about 5 minutes, Mr. Coleman, to address this motion as to why you think I should grant either one of your motions.
Okay. Thank you, Your Honor. Do you want me at the podium or can I stay here?
Right there is fine.
All right, thank you, Your Honor. May it please the court, Dave Coleman appearing on behalf of defendants. I think the big difference between what you had indicated earlier about the hearing and today is you've had a chance to review in camera the closed session minutes now. So that's a big difference. But I think this issue is clear. Attorney Howard, again, has based her whole claim for a final settlement on the written email exchange between counsel on November 6th, after closed session had ended, and the oral motion passed November 6th to accept corporate counsel's recommendation to continue the litigation activities. Her motion relies totally on the cited court rule 2.507G, and that requires a written and signed agreement for the court to enforce. That's the requirement of the court rule. Number one fell apart when Attorney Howard realized that the board had ended closed session prior to the email exchange, and we've been through this before, so I don't have to rehash all of that. The board was unaware of it and had not seen that email exchange, so clearly it was impossible for them to have been voting on that on November 6th. So her theory of this phantom agreement at that time, based on number one, that exchange is impossible. Then she shifted her argument to number two. the oral motion that was made and passed by the board. That somehow that was a binding agreement. Again, her claim's impossible. This court has now reviewed the closed session minutes, and you know we never made such a recommendation for a settlement during the closed session. Moreover, this oral motion is not in writing, as required by the court rule. There are no minutes yet of that meeting. There's nothing in writing, let alone anything signed. The November 6th hearing is still ongoing as we stand here today. It's in recess. So there are no minutes, there's nothing in writing under the court rule, which is a requirement. No oral statements or agreements are allowed for governmental entities. It's impossible. The law is clear, we cite it in our brief. Plaintiff is trying to enforce a verbal motion by Commissioner Moss. She cannot meet the written and signed requirements of the court rule to have a binding agreement. She just can't. It's impossible. Remember, Your Honor, Tavener, the other cases we cited, you cannot consider testimony of individual commissioners. The board speaks through its minutes and its motions and its minutes, written minutes, and its resolutions. There are no written minutes or resolutions yet because the hearing has not concluded. The board cannot legally make decisions in closed session, and you know they did not make any decisions in closed session because you reviewed the minutes. The only decisions allowed by law are in an open meeting. There are no minutes of any public decision by the board regarding this so-called agreement. She has no legal right, the plaintiff, to enforce an unwritten motion. There are no minutes because the hearing's still ongoing. She can call 100 witnesses today, Judge. It doesn't change that fact. How can plaintiff claim an OMA violation regarding a hearing that's still ongoing and it's not even concluded? The bottom line, Your Honor, is there is nothing written, signed by the board, for her to attempt to enforce. As to our other issues, the attorney-client privilege, which has never been waived by the board or others, potential criminal liability, all the reasons for protective order, I'll just rely on our briefs, and I know you've had the opportunity to do all that. We ask the court to grant our motion to cancel the evidentiary hearing and deny our motion to enforce this phantom, unwritten, unsigned settlement, so-called settlement agreement. Your Honor, nothing signed in writing. She has no basis for the relief she's asking for under the court rule. She cites no other legal authority. It's 2.507G, period. Nothing else. She has the duty to bring forward a signed written agreement. She can't. So what is the purpose of this hearing? Attorney Howard has to prove that writing exists. She can't do so. Judge, think about what she's really asking for right now. She's asking you to allow an evidentiary hearing to get oral testimony to somehow magically create a written signed agreement from the board. That's what she's asking for. And again, under Tavener, and I won't repeat all that, this testimony is meaningless and frankly can't even be considered by Your Honor in deciding this issue. It's impossible. Our motion should be granted. Thank you, Your Honor.
Thank you, Your Honor. Counsel misstates our brief and the law, in my opinion. The court rule says to have an enforceable agreement, you need a writing that is subscribed by both attorneys that states the major terms of the agreement. We have that. It's not required to have been seen or signed by the board. Being subscribed by both attorneys is sufficient. The email memorialized the terms that the board was about to go out and vote on, and Commissioner Moss's motion is vague for sure, and it violates the OMA for that reason. The board decided something. They decided it 7-3, and we believe what they were deciding was to affirm the settlement agreement, to agree to those terms which have been negotiated by counsel. That is why, and the reason why we need the evidentiary hearing, as Your Honor knows, as I've argued before, is because they violated the OMA by not describing the nature of the decision that they were making when they returned to open session on November 6th. We don't have any open session minutes yet because the board has continued over, I believe, 6 or 7 sessions at this point, the special meeting to terminate my client, and still hasn't closed the meeting or published the minutes. That's not our fault. And in any event, the motion itself talks about accepting a recommendation of counsel. I would also point out that the closed session minutes, and unfortunately, I'm at the most disadvantage because I'm the one who hasn't seen them, but there does not need to be the actual words in the minutes. Council's making a recommendation, council's giving legal advice. If what happened is that was impliedly or explicitly made, even if it's not reflected in the minutes, since they're not an exact transcript, and the board believed that's what they were voting on, it's sufficient to have created a binding agreement. As your honor knows, there's absolutely no requirement for a binding agreement that the party have signed a writing, so long as the party intended to enter it and the attorneys subscribed to the written terms, which were the substantial and major terms. Thank you, your honor.
Thank you.
Your Honor, just briefly, if I could respond, because I think there's a couple points here, Your Honor, if I could. Ms. Howard's incorrect. The statute is clear, MCL 46.3 parens 2. The board must vote and approve any claims. We cite it in our brief. She's simply wrong in what she's saying there. And we're not here today to argue an OMA violation. You know, I know she's amended her complaint and she's proposed an order to Your Honor. And frankly, you know, as a means to try to get the minutes in front of Your Honor, and that's fine. But we're not here today on that. And it goes back to, what is the OMA relief that she can get? Your Honor to make a decision and tell the board what it really meant? That's not the relief she can get under the OMA, the things that she cited. Section 11 says her relief is, it goes back to the board to pass a more clear resolution, or to pass a more clear motion. Not for this court to decide something else that the court didn't do. Even if Your Honor thinks it was vague, or it was ambiguous and the motion wasn't clear, so what? I mean, the only thing you can order is, okay, board, I'm sending it back, pass another motion, and tell us what you really meant. You cannot substitute your decision, Judge. So this is all bogus. This evidentiary hearing is unlawful. You can't consider whatever evidence is brought forward. And it's just clear. We just ask that our motions be granted. Thank you.
Well, and as I already stated, I do believe that Ms. Howard is entitled to an evidentiary hearing. I think there's issues of facts here. When I asked the question of what was intended by the motion, Mr. Common, you didn't have an answer. So I do believe I need to take she's entitled to an evidentiary hearing regarding what occurred, and we will, both of your motions are denied, and we're going to proceed with the motion. With the plaintiff's motion.
Okay. Then, Your Honor, I have another request. For purposes of appeal, then I request that the court state on the record what clear statute, case, or law that the court is relying on for its ruling that she's entitled to this evidentiary hearing.
I think I already stated that last time when we were here.
I don't recall any statute or law
I stated that she was entitled, there are issues of fact here. So I'm not making a decision.
I'm listening, Your Honor. Oh, I'm sorry, it's the, I got you.
I'm not making a decision on the merits of the motion, that's why we're having a hearing. So in order to have a hearing to determine the merits of her motion, I am requiring that we take testimony. That's it.
Okay.
That's what I'm deciding.
But Your Honor, you're denying our protective order, and you're denying it, and I'm just simply asking for purposes of appeal that the legal basis be stated clearly on the record.
You want me to state very clearly why? I guess I would say for all the reasons in her responsive pleading.
Okay. Then, Your Honor, then I would request a stay of these proceedings so that an adjournment so that we can immediately appeal to the Court of Appeals and have this issue determined at the Court of Appeals.
And your request for a stay is denied.
Thank you, Your Honor. Then my next motion is I request that the hearing be closed and that anything that is testified to in this hearing be sealed. It is crystal clear under the OMA. Those closed session minutes and anything that happened in that closed session is not to be revealed to the public. And even Ms. Howard admits that in her response brief. So to have a hearing, Your Honor, and if you order our clients to show up, you are ordering them to violate the OMA. So I would request that the hearing be closed and that anything that's stated in this hearing be sealed. Thank you.
What's your basis under the law that allows me to close the hearing?
Because the OMA says they can't reveal this information to, we've cited the statutes in our responses, Your Honor.
But that's a different, I have not ordered that those minutes be released, and I'm not going to.
Well, she's gonna be questioning our clients on those very issues. She's gonna be asking them, what happened in closed session? What did you guys talk about? What did you do? I mean, the whole purpose of her evidentiary hearing is for that reason.
What is your response, Ms. Howard?
Thank you, Your Honor. The law does not allow the hearing to be closed on that topic. The specific portion of the OMA that Mr. Coleman's referring to talks only about closed session minutes and not about testimony about what happened in a closed session. The legislature certainly understood how to restrict information on that subject if it wanted to. Also, I would say that and I prepared a bench memo on this topic, thinking that Mr. Coleman might bring it up, which I'm happy to share with opposing counsel and the court if you want. But the basics are that the legislature says there's only very rare circumstances in which a hearing can be closed under MCL 600.1420. And the court rules, in particular MCR 8.119D, says that a court may not limit access by the public to a court proceeding unless a party has filed a written motion that identifies the specific interest to be protected, or the court sua sponte has identified a specific interest to be protected, and the court determines that the interest outweighs the right of access. And the denial of access has to be narrowly tailored because the OMA is completely silent on testimony about what occurred in a closed session. When that's appropriate, I believe there's absolutely no justification or grounds that would be reversible error to order the hearing closed, Your Honor. There's clearly a great deal of public interest, and one of the reasons why our court proceedings are open is because it's the public's court and the people have the right to know how decisions are made and what they're based upon, Your Honor.
Your Honor, under the court rule, as just cited by opposing counsel, we have the written reasons in front of you in our motions for protective order, and it's spelled out. And we cited the case law on this issue. I don't have to repeat it all. And we believe we do meet the requirements of the rule.
Your Honor, may I be heard briefly?
Yes.
Your Honor, we joined, on behalf of Mr. Roebuck, I joined the portion of Mr. Coleman's request to either take testimony in chambers or close the hearing, and I base it on this, Your Honor. MCL 15.263 states, in part, all persons must be permitted to attend any meeting except as otherwise provided in this act. MCL 15.268 states the purposes allowed for a closed session. The closed session in this case was held under subsection 2E to consult with its attorney regarding trial or settlement strategy in connection with specific pending litigation. And then finally, MCL 15.267 states that a separate set of minutes shall be taken by the clerk of a closed session. These minutes shall be retained by the clerk of the public body, are not available to the public, and shall only be disclosed if required by a civil action filed under section 10 or 11 or 13 of the Act. While Ms. Howard is correct that the Act is silent as to taking testimony, for example, in open court from those attending a closed session, it would seem to me, Your Honor, to be kind of absurd for the legislature to allow a public body to go into closed session for a specified purpose, explicitly state that the minutes of that closed session may not be released to the public absent a court order under a specific section of the Open Meetings Act, but yet allow counsel to file a lawsuit and then inquire of the members of that public body what went on in the closed session. So I'm not going to belabor the point, Your Honor, but we do join in that, and we would ask the court to take the testimony in a closed setting. Thank you.
Any response to that, Ms. Howard?
Yes, Your Honor. None of those statutes say that this particular topic is appropriate for closed hearing. We have the other party who has said that who has alleged a particular affirmative purpose that the motion met, that the motion was to continue settlement negotiations. We have statements in the pleadings by defendant that there was no offers made or proposals made by the board pending their vote on our side, which again, first of all, we say is inaccurate, but also directly goes to the issue of whether or not we had a settlement. If the board had come out and specifically stated the contours of its decision, then yes, I would agree it would not be appropriate to examine, but they have opened it by making contrary factual statements and by denying the existence of the settlement agreement that we have a writing to back up our version of events, Your Honor.
Well, I guess here's my issue with this. So I've denied his motions, and denied his request for a stay, so he doesn't have the opportunity to go to the Court of Appeals today. If I close the hearing, I get the information that I need to make a decision on the motion, and if somebody wishes to appeal that issue, eventually there'll be a transcript that can be released. If I have a hearing and it's open to the public, that bell can't be unrung, like, it's out there. So I think they have a valid point that if this information is restricted by the OMA, that I do need to close the hearing. I think I need the information, just like I asked for the release of the minutes. But I think that they bring some valid points here as to closing the hearing in terms of what information is out in the public. I would agree with you. I tend to think that this is a matter of public concern. The public is entitled to know. But I also question under your argument under the OMA, if the public can't have the minutes, then I'm not sure the public can have all the information that occurred in it. So I think at this point, what I'm gonna do, I'm gonna grant their request to close the hearing. I'm gonna ask all, the media, unfortunately, is going to have to leave. The public is going to have to leave. The only people that are gonna be in here are the attorneys and then, the potential witnesses, and we can discuss whether they are sequestered in the hallway while we do the hearing. But I think that's my only option, because at some point, if I'm wrong, we have a transcript, the information can get out to the public. And if you're right, if you're right, and if they're right, then the information's already out there. So I'm gonna grant that request, and we're gonna close the hearing.
Your Honor, the one thing I would say for the record is that, there's a bell that can't be unrung from our position too, which is that even if a transcript is released later, if Your Honors were first on that point, the public still hasn't seen the witnesses testifying, hasn't seen their demeanor, how they looked, and been able to make many credibility judgments for themselves. For purposes of the record, I would also ask Your Honor that we be able to submit our bench memo to Your Honor and to opposing counsel, since this has not been the subject of a written motion per the court rule, and I would like to at least.
I'd like to have that part of the record.
Yes.
Do you have any issue with that, Mr. Coleman?
I haven't had a chance to look at it, Your Honor. As long as we have an opportunity to respond, I don't have any problem. If she's just putting it into the court now, if you give us a week or something to respond, I would have no objection.
Well, we also, here's part of the problem. The court rule says you can close the court on a written motion by a party. We don't have that here. I've only done my best to anticipate what I thought they were going to say. And so part of the problem is that we don't have the written motion that the court rule requires to do.
I understand that. I think their argument is that it is part of their request for a protective order. It's not called that. I probably would have preferred they file a motion saying close the proceedings, especially when at every other hearing the media has been in here. So I think all of us could have anticipated that there would be members of the public and the media in here. But I think, from my perspective, we need to keep this case moving. I think I've told counsel this before, I'm not one that likes to kind of delay. And I could adjourn, we could do more and come back, but that doesn't make a lot of sense to me. We need to get moving here. So I need to make a decision on this motion, and then we need to either proceed, either you go to mediation, you resolve it, fantastic. You don't, we have a trial and we get this resolved. I think that definitely is what benefits the public here. This issue needs to be resolved for everyone, for your client and for the entire county, quite frankly. I don't have any issue with you submitting that. You can submit a response to it too if you wish. But I think at this point, I'm gonna go off the record for a few minutes, give everyone the opportunity to leave, and then we'll reconvene here in about 10 minutes.
I would just also state for the record, Your Honor, that Mr. Kalman's motions contain nothing about this topic. It was not mentioned at all. The court rule, the statute, nothing was mentioned, so I would state that for the record also, Your Honor. Thank you.
All right. Pause.